Mention. Please do not. Worship, matrimonial appeal has to be listed, Worship, next week, anytime.
Or
This is against the decree of divorce, and we are for the respondent.
Order.
My lords,
Order.
for admission.
Admission.
Lordship, anytime next week.
With your lordship, I beg to mention a criminal petition for listing.
Criminal petition before divisionment.
Lordship.
Is it a case before divisionment?
No, Lord. Please, your lordship, I beg to mention for listing of a criminal appeal next week, lordship, in orders call.
Order.
Yes, lordship.
Court master give it.
Thank you. Like,
Jail appeal, lordship. For the first time, it's
302.
302. It's very old judgment, lordship. 28 2015. Sir.
Delay is condoned.
Delay already
Condoned.
condoned. Delay condoned.
There was a delay, so it is condoned.
You are legally
Yes, lordship.
hard. MS. P. Sharma. Legally counsel for the accused appeal. And MS. S. Rahan. Regional public prosecutor. Number 1, this criminal appeal from jail is directed against a judgment and order dated 20/08/2015 passed in Sessions case number 144 within bracket Satu EASC is 18 of 2015 passed by the Court of Learned Sessions Judge Srirang at Kajal. By the state judgment and order dated 20/08/2015, the accused applicant has been convicted under section 302, Indian Penal Code, and he has been sentenced to imprisonment for life, to pay a fine of rupees 5,000, in default of payment of fine, to undergo rigorous imprisonment for another. The appeal is admitted for hearing to as MS Mahan, learned regional public, has appeared and accepted on behalf of number 1.
Lordship, respondent number 2 is the official respondent, and in the IA for delay, we have taken steps, lordship, and it is observed that as he had already retired, lordship, so perhaps there is no necessity to issue notice.
Go ahead.
Picture capacity, no?
Interlocutory application.
Okay.
I criminal number 59 of 2000. Referred for seeking continuation delay in filing the instant criminal bill, comma, the court by an order date 20 in its order dated 20/03/2000 and observed that the respondent number 2 was not a necessary party for adjudication of the connected appeal as well as the state declaratory appeal. Accordingly, comma, the name of the respondent number 2 was ordered to be struck off. So, in view of the same, comma, there is no necessity to issue notice for the to inform as the name of the respondent number 2 is to be struck off from the array of response. Uh, case record of sessions case number 144 within bracket part 2 of 2015 we call for here the where
389, I'll file my objection. I didn't do it.
He is already 13 years behind the bar, so let the record come, Lordship.
as he from I
There also.
and MS as Jahan. Analytically responsible for application. And MS as Jahan. That is additional for the opposite party. The instant interlocutory application under section 389 in bracket 1 CRPC referred seeking suspension of the execution process passed against the applicant and for his release on bail. The applicant as the applicant preferred a certificate against the judgment and by in video. Issue notice returnable in with as against Jahan. Probably return as MS Jahan here deputy party of state of no court. So, in view of the observation made in the order passed today in criminal appeal jail number 41 there notice issuance of notice to the number opposite party number stands dispense with as its name has already been ordered to be strike. Prayer for suspension of execution of sentence will be considered in the on receipt of the record of the learned fact. The I object
striking of the respondent perhaps is, because if they want to come and appear, they can. How is that?
Certainly, because the
It was served to the council and
Got it. Oh, it was served to the council, he refused.
no,
Or
no,
he-
no, it was served. Then after that, informant had retired.
Acha, acha, that is what.
CGC has submitted before the court that he superannuated. The informant was commandant. He was in official capacity.
Official.
Filed the FIR. Then this court has said that as
Ah.
the respondent number 2 is not found to be a necessary party for adjudication of the connected appeal, as well as this interlocutory application, let the name of the respondent number 2 be struck off.
Oh, acha, there is.
What to do?
Oh, Lord.
for this
Then it's, I didn't
You have
hear.
not seen the order.
Nothing.
apply.
Please, Your Lordship. This is an appeal against conviction against judgment and order dated 2/3/24 passed by the
How
additional
many?
session judgment. Convicting the person for reverse
There
imprisonment
are
for
10
2 years.
appellants.
There are 10
Ten.
appellants.
Total there were 11, my lord. One
Huh?
died during the expiry.
Oh, one died. There
One
was
died
11.
during-
There were 11 of
Yes,
them.
ma'am.
One died during
Ah.
trial.
During trial, my lord.
At D-board. Then account for the accused appellant MS Jahan.
Those died.
Ah. The accused
go take.
appellant, attaining number, have preferred the female appellant of section 374 to against the judgment in order. Against the judgment in order dated 2/3/2020. Passed in session case number 38 of 2009 by the Court of London additional session judge command by the state judgment in order dated when the London trial, sorry, the accused appellants have been convicted for the offenses under section 326 RW, section 143, Indian Penal Code, and under section 302 RW, section 143, for the offense under section 326 RW 149. The accused appellants have been sentenced to undergo rigorous imprisonment for 3 years each and to pay a fine of rupees 2,000 each, in default of fine, to undergo further rigorous imprisonment for 2 months each. For the offense under section 302 RW 149, the accused appellants have been sentenced to undergo imprisonment for life and to pay a fine of rupees each and to pay a fine of 5,000 each in default of payment to undergo further rigorous imprisonment for 6 months. Both the sentences are to run for the trial court record of case number in 9. We call for police as an additional however, along that, the by any application
There is an IA, my lord.
opportunity to be considered after receipt of the
Objection within 2 weeks, sir.
Obliged, ma'am.
May it please your lordship. This is a statutory appeal, you know. Convicted petitioner is convicted under section 30234 for life imprisonment, your lordship.
how many Colin?
Lordship.
Hard mistake by learn account for the stage for a learn number of pain. Wednesday, 47. For the offense punishment under section 30234. The both the accused appellants have been sent to undergo rigorous imprisonment for life and to pay a fine of rupees 20,000 each, in default of payment of fine, or simple imprisonment for another 6 months each. Uh, section T1 bracket 2 case number 14 2014 judgment and order dated 5 March 2014. Court of Jurisdiction Judge Maka. I
I is there for suspension and
Same.
bail.
object
File up.
That's May I please your lordship.
My lord, appeal against conviction, my lord. Under section six
Also-
of
Boxer lot.
6 of
Eight steps have already been taken. However, correction is required to be made in paragraph.
offense. Yes, at the stage of contrary,
Lot.
we are following the procedure because the earlier division bench has issued the notice
Lot.
to the chain.
Yes.
But otherwise, matter of contradiction delay is between the court and the
Lot.
region.
Yes. That's it.
Informant will have participated right
Yes.
at every stage.
Yes.
Heard Mr.
B. Haldal.
B. Halder, learned legal aid counsel
Yes, lordship.
for the applicant. Appel. And MS Said Bora, learned additional public prosecutor for the opposite party. Yes, respondent number 1, 3. The instant interlocutory application under section 5 of the Limitation Act 1963 is deferred with a prayer to condone delay of 73 days in preferring the connected 73 days which is offered in preferring the connected date. The applicant sorry, the applicant as the appellant, comma, has preferred the connected appeal. Connected appeal. From jail,
From jail.
from jail. Against a judgment in order dated 7/11/2023 passed in special within bracket P case number 68 of 2016 by the Court of Learned Additional Sessions Judge cum Special Judge within bracket POCSO, comma, I mean, until and unless the appeal is born,
Lord,
I dispose of.
I dispose.
May it please your lordship. Lordship, on the last day, your lordship has directed me to apprise on 302 and 304B as well
so
as
we have
on the.
given you opportunity.
Yes,
We have
yes.
not directing.
Yes, yes.
We did not
Lordship has
direct.
given us opportunity, so
We have given you opportunity on your behalf.
my lord, 302, 304 BIPC as well as on the point of soon before date. Lordship, I have prepared a synopsis of my argument. Lordship. I took. I would like to, lordship, go by this synopsis, lordship.
Paragraph 6. I have not read the judgment, the Tarmes thing. You have the copy,
Yes, yes, Lord.
and that would be a case of suicide for it.
I have given lordship books of leave.
The Tarmes thing.
Yes,
Paragraph
2000,
6.
2008, 16 SCQ.
The judgment will be, definitely will be regarding suicide. Find out.
Yes.
What is the cause of death there?
Indisputedly, again, the deceased had mostly been residing with her parents. 10 days prior to the date of occurrence, the deceased came to her house and disclosed that Tarsem Singh had written a letter to her parents asking them to turn her out of
Due
the
to
house.
consumption of,
So it is a case of
Organophosphorus.
suicide.
yes.
Danger of self-
This is a case of suicide, but in our case, this is different. But my lord, my submission is that, my lord, to come under
See,
the ambit
there are
of 30,
So for 304B is concerned,
yes,
one thing is clear, it is within 7 years of.
yes,
Second thing is also clear that it is a death which is not nature.
Yes.
Right? You have not brought, he did not die natural death due to old age. She did not die due to any serious ailment. Right? So, normal young lady,
21,
30,
21.
21 years. So it is death, the unnatural. Or it could be, it may include suicide, suicide, or any, right? The third factor, that soon before, there was a demand. Suppose if this third factor is found favor with the court, then the mandatory presumption under 13B gets operational. Then honors gets shifted to the accused, right? And it is your honors to rebut
that presumption.
by
Cross-examining or by adducing
leading
defense.
evidence or by making some explanation plausible, maybe 330. Tell me on that.
Yes, my lord, my submission is that,
Okay,
my lord,
soon before you have given
there is
the
no,
judgment.
there is no proximate live link between the effect of cruelty based on dowry demand and the death concern. That is my humble submission, and therefore, my lord, my lord, presumption cannot operate, my lord. Because, my lord, here PW2 in her evidence deposed that she was
Don't repeat whatever you have said, just be precise.
PW2 in her evidence, he deposed the accused had gone to our house 10 days prior to the incident and demanded rupees 2 lakh from us. Since we could not meet his demand, he made a nuisance and left my house. Only that much, my lord. Thereafter, my lord, no such allegation of that sort, my lord. On 16/1/2016, the accused came
And
to
this
our
10
house,
days is in continuation
my lord, my lord,
of earlier events.
my lord, for last, my lord, before the date of incident, my lord, there is no such allegation of cruelty or harassment. So therefore, my
Whenever
lord, my
you
respectful
see-
submission is that
You make a visit to your in-laws house 10 days prior to the incident, created a nuisance, demanded the money. That is what the informant said.
PW2 says,
Right.
yes,
Then left it after creating a nuisance.
Yes.
Then you again came back after 10 days.
yes.
This is the, now let us see what kind of cross-examination you have done. The incident prior to 10 days, because they could not meet the demand. As a result, you assaulted, and the lady had to leave the house along with her child. No normal person they have returned.
But
And this is not soon before, it is not a fixed.
yes, there is
it
no
is
such
flexible,
any
it is not
specific,
flexible.
there is no such specific time frame.
Parameter.
But there must be some, my lord, live link, my lord. From my submission, my lord,
So there is one, okay. We have
there is no live link, my lord. And there is no proximate relationship because on that particular day, on 16/1/2016, the accused came to our house again and said that he would not subject my daughter to torture demanding money. I told my son-in-law to stay in my house. He went
okay, what
out.
is the other one? Whether 304 B and 302 can go together or
Yes, my lord, to that effect, my lord, I have, my lord, I have, my lord.
tell me,
2014, 15 SCC 163.
what does it say?
That says, my lord, 302, my lord, that can be treated as, my lord, main charge, and in alternative, 304B can be added. And if the court founds that there is no material of 302, then trial court will look into the aspect of whether there is any material of 304B or not.
Which paragraph?
My lord, paragraph 18, 19, 20, my lord. 19 may kindly, 18, my lord. May I read, my lord? However, 18, however, it is generally seen that in cases where a married woman dies within 7 years of marriage, otherwise than under normal circumstances, no inquiry is usually conducted to see whether there is evidence, direct or circumstantial, as to whether the offense falls under section 302 IPC. Sometimes section 302 IPC is put as an alternate charge. In cases where there is evidence, direct or circumstantial, to show that the offense falls under section 302 IPC, the trial court should frame the charge under section 302 IPC, even if the police has not expressed any opinion in that regard in that report under section 173(2) CRPC. Section 304B IPC can be put as an alternate charge. Alternate charge. If the trial court so feels, in the course of trial, if the court finds that there is not available to establish that the same is not homicide, in such a situation, if the ingredients under section 304B IPC are available, the trial court should proceed under provision of so and so. This court addressed the issue and held as follows. A reading of in section 304B IPC and section 113B Evidence Act together makes it clear that law authorizes a presumption that the husband or any other relative of the husband has caused the death of a woman if she happens to die in the circumstances not normal, and that there was evidence to show that he was treated with cruelty or harassed before her death in connection with any demand of dowry. It therefore follows that the husband or the relative, as the case may be, need not be the actual or direct participant in the commission of the offense of death. For those that are direct participants in the commission of the offense of death, there are already provisions incorporated in section 300, 302 and 304. The provisions contained in section 304 BIPC and section 113B of the Evidence Act were incorporated on the anvil of the Dowry Prohibition Act 1984. The main object of which is to curb the evil of dowry in the society and to make it severely punitive in nature, and not to extricate husbands or their relative from the clutches of section 302 IPC if they directly cause death. This conceptual difference was not kept in view by the courts below, but that cannot bring any relief if the conviction is altered to section 304 part 2. No prejudice is caused to the accused appellant, as they were originally charged for offense punishable under section 302 IPC along with section 304 BIPC. In recent decision, this court in Jaswinder Saini versus State observed thus, it is common ground that a charge under section 304 BIPC is not a substitute for charge of murder punishable under section 302. As in the case of murder, in every case under section 304B also there is a death involved. The question whether it is murder punishable under section 302 IPC or a dowry death punishable under section 304B IPC depends upon the fact situation and the evidence in the case. If there is evidence, whether direct or circumstantial, to prima facie support a charge under section 302 IPC, the trial court can and indeed ought to frame a charge of murder punishable under section 302 IPC, which should then be the main charge and not an alternative charge, as is erroneously assumed in some quarter. If the main charge of murder is not proved against the accused at the trial, the court can look into the evidence to determine whether the alternative charge of dowry death punishable under section 304B is established. The ingredients to constitute the two offenses are different. Yes.
Here, take a
304B.
is generally more publicized, otherwise than not. Let us see again. 304.
Where the death of
Okay,
a woman
okay.
is
So it's caused by
yes is
one,
yes.
any part.
yes yes
First, let us analyze why you are going to your case.
yes
We are into the subjective provision.
Yes.
Firstly, part. Secondly, bodily
injury.
injury. Thirdly, occurs otherwise than normal circumstances. Third is unnatural death.
Yes.
Three things. Thirdly, otherwise than organ. So one is burn, second is bodily injury, third is otherwise than normal circumstance, which could be suicide also or any kind of death other than natural death or death due to serious health ailments. Right? Now, this is very specific. Bodily injury. Right? So three situations were envisaged. Right? Then within 7 years of it, bodily injury can go with death of a woman is caused by any bodily injury within 7 years of her marriage, and if it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband, for or in connection with the demand for dowry, such death is called dowry. Right? And if the bodily injury is fatal with the intention to cause death, then it comes under 290, 300.
Yes.
First 299, then whether it will come under 300 or not. That is on the dependent on the facts and circumstances of the case. So bodily injury come to again 299 with the intention of causing such bodily injury as is likely to cause death. And death appears to be instantaneous death.
Well, Lordship, it cannot be said that she died immediately because she was first taken when from the version of PW2, she deposed that at that time she got the,
You were there inside that room. So tell me what you have said to rebut that no, it was a death much there.
my lord, on
See,
respect of
whatever is available, that has to be.
yes, yes.
So,
I cannot go beyond
sympathy,
that.
empathy is not to be drawn here. What is there on record?
But in regard to explanation, my lord, there is
no
nothing.
explanation.
No explanation that I admitted, Lordship, in cross-examination.
See, whatever
There is no
is
sufficient
there,
explanation. But, my lord,
whatever is there, you have to make sufficient on that.
yes, my lord, my submission would be, my lord, as my lord, the demand of dowry, my lord, was made
No,
10 days prior to
what
that.
about the higher offense? 302. I asked you two.
Yes, my lord, regarding
I asked you two
302,
questions. Whether both can go together or not. Because I was not sure. But to say whether they can go together or not.
my lord, first it will come under 302. Then, my lord, in alternatively, my lord, 304B. And, my lord, if the,
No.
my-
That observation was made particular context. Now, if we have the IPC in our hand with 304B and 30299 and 300,
yeah,
right?
Yes.
From that, whether it go together. That is what, after analyzing the problem, dowry death includes bodily injury.
yes, it can go together.
Go
It
together.
can go together, my lord. To that effect, my lord, there is no
Now,
doubt.
whether ingredients are can be possible to be available in a particular case. Ingredients of both the offense.
There may be ingredients of both the offense.
The-
There may be ingredients of
This is a
one offense.
case. Let us see the postmortem report.
Yes.
Your written submission is that ligature. What is ligature?
page 60, postmortem report.
Go to page 57, in page. Some marks,
Some
here
marks.
underneath.
Some marks.
He is not an expert.
Yes, yes.
Page 61. Ecimosis change. Approximate so right side of name. It is. Base pale. Leaf cyanide. Bruise. Leaf is bruise. On back of neck. Mark of ligature on neck, right. Injury on neck. Basic. In my opinion, basic cause of death is conflict. So it is asphyxia or obstruction of air.
Yes.
One is made not to breathe. One is made not to breathe air. To lead to death.
Yes.
So as per there is a, and what is the evidence of the mother?
PW 10.
What did it say? It was mother.
PW 2.
Strangulating. Page 13.
I heard the child of my daughter crying, whereupon I entered that room and saw my son-in-law strangulating my daughter by sitting upon her chest.
Not by any ligature. So if there that is not by ligature, there cannot be any ligature mark. It will be by
That
so
is the
your written submission that there is no ligature mark. That does not bear any relevance. Your written submission.
because, my lord, they are only, my
Because the
lord,
evidence is direct eyewitness account is strangulation.
but there must have some injury, my lord. Here only ecchymosis. Whether that ecchymosis amounts to cause of death.
You explain then. You explain under 106. You were there with your wife. You explain as per Timuk or Tikirkan.
My lord, yes,
No, no,
lordship is correct, my lord. That
How
on
your
that aspect,
wife,
my lord, that
when she
no
was
cross-examination.
in the same room, died. You explain.
That is not available.
Huh?
That is not available in the cross-examination. No such explanation on that regard.
So prolonged submission here and there will not do. There is no explanation from your side. You were there. There was never any attempt to you have taken a plea of illegal. Or you were not there at that time inside that room. There was nothing. You were there, admittedly you were there. In fact, you tried to explain in your T13. So those persons have not come to the witness at
True.
that time. Meaning thereby indirectly you have admitted your presence. Why not
Presence, yes. In that
admitted
aspect,
your presence?
I have nothing to say regarding his presence, my lord.
Lordship, ingredients of 304P as well as 302 is attracted instantly. Lordship, may I again repeat 304B one?
This is before.
Lordship,
Whenever a death of a woman is caused by any burn or bodily injury
injury,
or under
normal circumstances
under
within
the
7 years.
circumstances,
So in
within
that,
7 years
yes,
of marriage,
marriage,
and it is shown that soon before such date,
she was
the has been
subjected to
made.
cruelty or harassment by her husband or any relative of
Yes.
husband. So, first ingredient, she was died not under normal circumstances, my lord. And date was within 7 years of
It is
marriage,
normal circumstances or bodily injury. Tell me.
lordship.
See, there are or
Yes,
any burn or
or
bodily injury or
yes,
what?
or otherwise than under normal circumstances.
Now here is a case from the postmortem examination report as well as the evidence of PW2. It is a direct case of
Throttling.
strangulation.
Strangulation,
If it is
So
case
it-
of strangulation,
my lord.
it comes within the purview of bodily injury.
Bodily injury, it would come. And your lordship,
Then also
yes.
it will be within 304B.
So I said the ingredients of 2 sections are
So
fulfilled,
it is not a case. These are all etc.
lordship,
Two specific cases.
my lord.
One is burn. One is bodily injury.
Good.
And all other etc.
Exception like suicide and all.
etc. Otherwise than normal
Normal
circumstances.
circumstances.
Huh?
In the case in hand,
Normal is natural death or whatever
my lord,
due to old age.
Right.
So etc. will come in the third category.
my lord.
Here is a case. It is a case of bodily injury.
Bodily injury. And your lordship, the ingredients of section 304 are fulfilled, 304B, as well as section 300, my lord. May I take your lordship to the section 300, my lord, Indian Penal Code.
For three in wisdom, I have strangulation. Strangulation is what? Throttling.
Lordship 300,
Meaning throttling.
my lord,
The PM report.
my lord,
By choking
my lord.
or strangling.
Here, my lord, throttling.
So this is not a meaning,
Yes.
but there is difference between strangulation and throttling.
Throttling.
It is same. Attack or kill someone by choking. Choking means stoppage of
Air passes.
breathing
Breathing. Air passes.
or strangling them. So there is no difference. It goes consistent with the version of the PW2.
Now I take your lordship to the section 300,
Section?
300 by IPC.
Yes.
Except in the cases hereinafter accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death. So, your lordship, in the instant case, the bodily injury was done, the act of throttling was done, your lordship,
Act.
as a result of which she died
It's the
instantaneously.
act by which.
Yes. So it would come under the provision of 302. My lord. And your lordship, now I take your lordship to the postmortem report at page 61. Wound's position and character. Ecchymosis approximately 5 cm, left half cm. So, lordship, I tried to measure my own finger. Lordship, it amounts to like length of a finger, 5 cm. It is mine, my lord. It may be general, maybe normal human being. And the breadth is half centimeter cm. So it will, lordship, I think, lordship, it corroborates the evidence of PW2, the throttling was done. And regarding soon before her marriage, my lord, whether 10 days of This one, my lord, the
Soon before the date.
date, soon before her death, 10 days will come within that period. Lordship, may I take that Torsam Singh case, my lord? Para 25. Lordship, para 25 and 13 paragraphs of it, even para 22, my para 22, my lord, down below. It is not enough that harassment or cruelty was caused to women with demand of dowry at some time. If section 304 is to be invoked, it should have happened soon before her death. The said phrase, no doubt, is an elastic expression and can refer to a period either immediately before her death or within a few days or even a few weeks before it. But the proximity to her death is the pivot indicated by that expression. The legislature object is providing such a radius of time by employing the word soon before her death is to emphasize the idea that her death should in all probabilities have been the aftermath of such cruelty or harassment. In other words, there should be a perceptible nexus between her death and the dowry-related harassment or cruelty inflicted on her. If the interval elapsed between the infliction of such harassment or cruelty and her death is wide, the court would be in a position to gauge that in all probabilities the harassment or cruelty would not have been the immediate cause of her death. It is hence for the court to decide on the facts and circumstances of each case whether the said interval in that particular case was sufficient to snuff its court from the concept soon before. So, Lordship, the ingredients of both the sections are my submission is fulfilled. And they don't deny that he was not present. He was very much present. No effort to save our mind. And no defense to that effect. One more factor, my lord. Section 302 was inserted. Lordship, Rasbir as Raju and another was the state of Haryana. My learned friend has also referred to the matter. Here, the Honorable Supreme Court has directed all the trial courts, Your Lordship. It was reported in 2010-15 SCC 116, my lord. We further direct all the trial courts in India to ordinarily as section 302. Lordship. Overrule. Oh, that was diluted in subsequent year 2014. Yes, to Supreme Court 841. It will depend upon facts and circumstances. Depend upon the facts and circumstances. Which case? Rasbir to that year 2014 841. So, 2015. Lordship, I think, Lordship, my submission, the prosecution could prove the case beyond the. And all the chains are complete, madam, in order to substantiate the case under 302. And the other ingredients of 304B are also fulfilled. Motive, when direct evidence is there, Your Lordship, motive may not be an integral part because the eyewitness is the mother, my lord. So, Lordship, motive may not be an integral part. And other way around, Your Lordship, since she could not fulfill the demand of dowry.
What you wanted to say regarding ecchymosis?
My lord, ecchymosis means, my lord, discoloration of, my lord, skin. My lord. So, my lord, here, my lord, my
This
submission,
bill leaves sinusoid, right side of neck reduced. Can you explain it? Maybe? Discoloration to be definitely. Yes, lip becomes blue.
yes, my lord,
That it's
regarding motive part,
loses all its significance when there is time. Motive does not come in here. Oh. Whether we are trying to see whether this transport is credible or not. We have found now from all angles the testimony of PW2 credible. It hasn't been taken or discredited by defense in any manner whatsoever. And the consistency is found in the medical evidence. And discoloration will be natural consequence of strangulation. Is it all
That-
right or wrong?
yes,
Is it right or wrong?
that will be definite.
I have made my comment on common sense. Tell me, medical. It is cyanosis. Is a consequence of strangulation. It is to be found in general postmortem finding, fluid discoloration of the Mr. Doctor, you are amicus.
Amicus.
Take your seat.
May I point out one thing? In the, my lord, PW2, he deposed that then I removed the hands of my son-in-law and sounded an alarm. In the paper book, when that question was put before the IO, page 32, it is written, she has stated before me that the hand of the accused was not removed. So, my lord, may kindly compare, my lord, what is actually in the, my lord, in the original one, lordship. And my lord, here, my lord, the accused person is all along in jail hazard, and one minor son is there. She was at the time of death.
Mr. Doctor, in the cross-examination 32, if you want to contradict, to bring out that contradiction, that I removed the hands of my in-law and sounded an then IO said Satina did not tell before police in 161 statement. That is which page?
32.
He has stated before me that the hand of the accused was not removed.
That means he had not done such type of regarding removal of hand.
So, what is the significance under the evidence?
My lord,
What is my query is precise. Your answers should be precise and pointed.
lordship, she has developed that person in
That
her
development, how do you prove?
because admittedly that
Mr.
fact was
Doctor,
stated
please,
before the 161.
please, how do you prove? How do you prove it?
My lord, 161 statement is for contradiction, my lord.
What? How? How?
My lord, when during cross-examination, my lord.
How to prove it? This contradiction. What is the manner?
The manner,
What is
my
the
lord,
procedure?
regarding my lord, manner, my lord, that is not properly adopted, my lord, that I admit.
Then please don't disturb when I start dictating.
He is committing the minor son or daughter is there of the accused person. I did not see any victim compensation. after deliberate.
The instant criminal appeal from the is direct against a judgment an order dated 16/3/2018 passed by the Court of London Additional Sessions District and Sessions Judge, FTC, हो जाए as Concord in station case number 25 in 2000 by the state judgment and order dated 2000. The accused applicant has been found guilty of the charges for the offenses for both the offenses under section 302, Indian Penal Code and section 304B, IPC. Judgment dated 16/2018 and order on sentence dated 19/2000. Huh? By the state judgment and order by the state judgment, it and by the order on sentence dated 19/2018, the accused applicant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of 20,000, in default of payment of fine, to undergo simple imprisonment for further 4 months, for the offense under section 302 IPC. For the offense under section 304B, the accused applicant is sentenced to undergo rigorous imprisonment for 10 years. Both the sentences are ordered to run concurrently. So, the prosecution, the investigating was set to after institution of a first information report by 1 Timothy Athena, report officer in charge to 17. In the state affair, three accused persons, including the accused applicant, were named. The accused appellant was the husband of Timothy Juma Paul, who was the daughter of the informant of Timothy Atina. Within the other accused persons in the affair were the mother of the accused appellant and the sister-in-law of the accused appellant. In the said affair, the informant had immediately acknowledged that her daughter was leading her conjugal life with the accused appellant. In a tenanted room at Mosaic Winter Colony for about last 2 years, and it was alleged that the accused appellant used to torture the daughter of the informant both physically and mentally. Demanding dowry, was unable to bear the brunt of torture meted out to her by the accused, the daughter of the informant had to take shelter in the house of the informant along with her 14-month-old child. About 2 months earlier, by specifically mentioning about an incident, the informant stated that at around 16 on 1,000, the accused appellant came to the house of the informant and promising that he would not subject the daughter of the informant to infant. He stayed for that night in the house of the informant. But at around 12:30 a.m. on 17th, strangled the daughter of the informant bed, and she witnessed, and the informant witnessed the same. The informant further alleged that the other two accused were involved in it. On the receiver of the affair, the officer in charge Uday registered the claim as Uday case number 15/2000 for the offenses offense under section 3 IPC, and investigation of the case was trusted by Srinu Kuan, a sub-inspector of this attached to Jaipur. The investigating officer is yeah. conducted and conduct and prepared a statement of the place of occurrence. Certain items were seized by memo leader. The eye of the case to a to an executive magistrate conducted inquest on the dead body of the deceased, that is the Dr. Fahim, on 17/5, 17/1, one 2016, and thereafter forwarded the dead body for postmortem examination at the BP Civil Hospital, Nagaon, wherein the postmortem examination was performed on 17th. The accused applicant was arrested on the date of the incident.
Yes.
The date of the incident.
Yes.
The date of the incident itself. Any point of time bail? Any point of time he was on bail? No idea.
Because my lord, when the charge sheet was submitted, he was on jail. When the charge was framed, he was on
Failure to cycle. Date of the incident. I have practiced. A chart white circuit on 29/01 finding a primary for the offenses under section 302, and section 3/4, dowry prohibition, well established against the accused. Yeah. On receipt from the third, the court of that is subdivisional legal case, secured the production of the accused from daily custody on 25/04/2000. After compliance, the third furnished copies to the accused and the CRP. A code of Lordship committed the case record of here case record of here to the court of six Nagaon. No. हो जाए
हो जाए
हो जाए court has the is exclusively time was unfair record.
he was all along inside the
It is easily possible to find out that here it is
oh yes
period of
yes
imprisonment,
definitely
8 years.
yes
Will resume. Keep the case records of your case number 97 pursuant to the order of 25 Court of registered the same as patient 25 and after securing the from jail and after hearing the learned of on 7 frame the Supreme it court the charges were read over explained to the immediate during the course of that it examined 11 number of cases and exhibit 6 number of accused of the order of the evidence for the prosecution side accused the section given was that of intent and the accused was asked whether they used any defense evidence, any evidence, he declined to use any evidence. Defense ability of the evidence of the court for the offenses the M. Dot law that declared from you keep me under assisted by and Mr. Dr. Learning declared for you submit by conviction of the accused is not sustainable either be or a as ingredients either the sequel are found at showing attention to the of a provided and and section three it is submitted by him that none of the four equations provided section 300 is present. According to him, as there is no rule and no indicator the make of the disease, comma, cannot be said that the date of the disease was homicide. Yes, it is submitted. Yes, content is the postmortem examination did not refer to anything regard to the underlying cause of echymosis and the prosecution has failed to prove the conviction of murder by the accused in all reasonable doubt, and there is possibility that the death might be natural also. The conviction of the accused is not in such case. The benefit of doubt should go to the should go to the as regards the charge the report he has submitted that there should be prolixity of any act of demand for dowry or harassment demand in dowry to the debt, which must be unnatural, which must be for reasons otherwise than normal. He has contended that the informant within bracket PW had alleged that prior to 10 days prior to the date of the deceased, the accused had visited his matrimonial house after meeting and met the deceased and demanded dowry. Such an act cannot, according to him, be said to be proximate to the date of the deceased, to come within the phrase, quote unquote, soon before her quote. He has further contended that the presumption under section 113B of the Evidence Act could not be taken resort as there was no evidence to that quote unquote court party disease was subject to cruelty or harassment by the accused. To buttress this committee, Mr. Ratto has referred to the in Hirala State Government of bracket, reported 8 as and Sutiram for the state of 2008 7 third. Yes, anything more? I'm asking and has support the judgment order of conviction. It has been contended by that the ingredients required fulfilled for the case of dowry debt defined have been proved by the beyond the real, whereas the requirement in such a case for the product, the ingredient beyond of that uh, probabilize the for the presumption and the operate. There is on the press code to appearing and the requirement is of existence of a proximity and life link between the effect of weight based on dowry demand and the concerned state. The incident which occurred 10 days prior to the date of the case and the date the disease on 7 comma by no state, comma can be said to be not proximity. It fulfills the idea of proximity as the legislature has not laid down any definite period. And I expect court soon court is not defined. The determination of period from the point of policy is dependent on the extent of a given case, as the interval between the concerned act of will or harassment and the date of death is hardly changed, and there is evidence that even prior to 10 days of the incident, there were constant demand for dowry and for as a result of it, the disease leaves the company of youth and was put in her cell phone. A clear demand for dowry has as he has started if the date of the disease is due any of the situation by 300, I think then the accused can be convicted both as well as and as the individual. So at present, the blood trial has rightly convicted the accused as a command with the impune here that something
The same thing, madam, that soon before 2008 16 SCC 155. Para 25.
25
Yes.
and inside 20
Yes.
it will be holidays,
Yes, ma'am.
right?
Yes.
MS has like the starship versus data particle query the brain concept comma soon before my before has been also record available in stations in number 25 and uh, my original one the it's like it apart. The informant who was the mother of the deceased within bracket Numa Paul bracket comma was examined as PW in her testimony. PW deposed to the effect that the marriage between the deceased and the accused was its article. So after the marriage, the deceased and the accused stayed in Shillong for housing, and thereafter, they started staying in a tenanted house at Govinda, PW further stated that the accused is right her daughter bring this back from her parents. And her daughter, that is the people, informed her about him by coming, visiting, coming to her parents. PW2 further stated that the demanded money, the amount demand from them could not be paid to the accused due to poverty. So the accused used to assault and torture his wife as the parents of his wife could not meet his demand. As a result of assault and torture, her daughter had to come back to her parental house with her child. PW2 further stated that accused had visited their house 10 days prior to the incident and demanded rupees 2 lakh from them. So since they could not meet his demand, he made a nuisance and left their house. It was on 16/1/2016, the accused came to the house of the informant again and said to them that he would not subject, said to her, and said that he would not subject her daughter to torture demanding money. Then, PW2 stated to the accused to stay in their house. On 16/1/2016, the accused went out for a walk after taking evening tea, and after returning home from the evening walk, he took his meal. Thereafter, the accused was told by PW2 to stay in a room along with her daughter. It was at around 12:30 a.m. PW2 stated to have heard the cry of the child of her daughter. So hearing the cry, she entered the room wherein she saw the accused strangulating her daughter by sitting upon her bed. So then she removed the hands of the accused and sounded an alarm. So then the husband of the PW2 PW3 of the PW2 got up and came to the room. So thereafter, other people also gathered at the spot. PW2 further deposed that the accused tried to flee, but he could not do so. Her daughter was at that time, was finding difficult to breathe, and she was taken to Ojai Civil Hospital in an authority as she was not kept there, as her daughter was not kept there, she was they took the her to another hospital, HAMM, where she was declared dead. Accused was apprehended by police on that very night. The dead body of the deceased was taken away by police, and the azar and the FIR was lodged on the following day, 7th, the following. So the PW2 exhibited the FIR as EXT2 with a signature thereon as EXT2 with a in her cross-examination, PW2 stated that the marriage was solemnized at Jamaica, and the accused was a driver by profit. PW2 also stated that the door of the room which the deceased and the accused had slept was open. It was deposed by PW2 that a festival was going on near the house on the date of the incident. A festival was going on near their house, and music was played there. PW2 denied suggestions to the effect that the door of the room wherein the accused had slept was closed. Semicolon. That she did not remove the hand of the accused from the neck of the deceased, semicolon. And that the accused did not squeeze the neck of the deceased. PW2 also denied the suggestions to the effect that she did not state to police that she had removed the hands of the accused. The presence of persons named Monica Mondal and Tapati Das PW8 and Tapati Das PW7 at the place of occurrence after the incident at the house of the informant after the incident was acknowledged. It denied the protection that the accused was massaging his daughter as she was unwell, and that the accused did not squeeze the neck of the Vera. The husband of the informant and the father of the deceased testified as PW3. PW3 like PW2, deposed that marriage between the deceased and the accused was solid from 3 years earlier. He corroborated the testimony of PW by deposing that initially the couple stayed in Ceylon and thereafter they shifted to Ujjain and started staying in a rented house at Govinda. PW3 also corroborated supported the testimony of PW2 by stating that the accused used to assault the deceased, demanding money, and as a result, the deceased had to return back to her parental house. Like PW2, PW3 also stated that the deceased was staying in their house for about 2 months, and during that time, the accused came to their house and said that he would not assault the deceased anymore by demanding money. As regards the incident, PW3 stated that on that day, after taking tea, the accused went out for a walk. So after returning from work, he had his meal and was sleeping in their house. PW3 testified that the deceased and the accused were in a room at night, finding their granddaughter crying, his wife within bracket PW2 entered that room and saw the accused squeezing the neck of their daughter by sitting up on her chest. Then his wife within bracket PW2 sounded alarm and he got up and went to that room. He stated that other people also arrived there and the accused was kept apprehended. PW3 supported the version of PW2 in that the their daughter was first taken to the civil hospital, and she was not admitted there, comma, she had to be taken to another hospital, comma, Ham Hospital, where she was declared ill. So, where in the cross-examination, when PW3 was cross-examined, PW3 also stated that the marriage was solemnized at Kamaikka. He denied the suggestion that he did not know anything about the incident. He stated that he admitted that he stated before police that they had got the disease and the accused shifted to Pujai from Shillong and made them stay at Pujai in a tenanted house, wherein their granddaughter was born. PW3 clarified that the accused visited their house once during the period of 2 months. He further stated that the disease was not in a position to speak when he saw her. The disease appeared to have breathed just 2-3 times. He denied the suggestions that the accused did not commit any assault on their daughter demanding money, and he did not see the accused within the neck of his mouth. Resume at 2 MS. PW. The elder brother of the informant was an uncle of the deposing about the incident which occurred in PW court at matter of one intervene within by PW call is your brother of PW 5, comma, 3, informed that it is informed of him and he and PW4 along with his younger brother visit him, went to the house of the finding of his needs, Jumapol, very critical, and seeing his younger sister, that is the informed bishop, wailing and weeping, comma, he took Jumapol to the civil hospital, Ujjain. According to PW, comma, both the informed PW2 and the accused accompanied them. The doctor there declared Jumapol dead. Later on, comma, he was told by PW2 that the accused bishop, that it is demanding rupees 2 lakh. And the accused had strangled that it is by sitting up. Yes. He found a black mark present on the neck. That is up. In his cross-examination, video report stated that the present at the time of the house of the informed computer situated about 10 kilometers from his house. When he reached the place of occurrence, a lot of people had already gathered there. He stated that he did not state the police that when they were taking Jumapol to the hospital, they were accompanied by the informant with 5 2 and the accused denied the suggestion that PW2 did not tell him that the accused had Jumapol by sitting up. But yes, he also denied the suggestion that it did not take it, that there was black mark found on the neck of Jumapol. PW5 was is another is a younger brother of the informant of PW and an narrating about the PW5. He was informed by Sri Ravindra Dev a neighbor of PW at around 1 p.m. The night 7 in 1. Whereupon that the condition of Jumapol became very critical, and he should be at the her house immediately. Then he informed his elder PW4, whereupon PW4 accompanied by his younger brother went to the house of PW5 his elder brother took Jumapal to the hospital where a doctor take care Jumapal. PW4 informed him about the event and he rushed to the civil hospital to take stock of the then PW5 was told by that the accused had Michael Jumapal and he had been torturing Jumapal from her since a couple of months prior. PW5 also stated that his needs from the disease also intimate him. PW5 stated that unable to bear the brunt of torture meted out his needs from Jumapal by the accused commands he had taken secretary of her mother, that is the actor's sister. PW5 further stated that accused tortured Jumapal about 10 days prior to the incident of death by visiting the house of his elders. He exhibited the inquest report with his signature thereon and its on proof. Stating that the inquest was performed by an executive. He denied that he did not state before the police that Ravindra PW9 did not make any phone call to him. That on getting information that Jumapal was unwell, he had sent his elder brother. That he noticed a black mark on the neck of the. He also denied the allegation that PW2 did not tell him that he used the triangle Jumapal. And Jumapal did not inform him about the demand of his black by the para. PW is a neighbor of PW and he stated that he knew that he deposed that the incident was at around 1 a.m. in the night when hearing he went right from it. He went there, found Juma dead. Juma called. Yes. Juma Paul was found not breathing, and the accused was standing near by. He found the informant from a PW and he was told by PW that the accused had slain her daughter Juma. PW hearing the sound of foot pumping of her daughter against the bed. Hearing heart. Tumorous maternal uncle came and took her to a doctor, and the doctor declared her dead. He, PW, stated to have heard that there is to be quarrel between the accused and the disease, and the disease said that there was a demand for his food. According to him, there was a treatment on the think of that in his cross-examination, PW stated that the time of the incident, it was the date of birth, loudspeaker, that short distance of the place. He found when he reached the place of occurrence, he found that parents of Jumapur at the place. He denied the suggestion that the informant on PW2 did not tell him that the accused had strangled her. And Jumapur did not tell him that the accused had demanded to act. He further denied the suggestion. He did not state to police that he had informed the maternal of Jumapur and that he had received a trademark PW7 a neighbor, a neighbor of the informant, PW2, deposed to the affected. It was at around 1 a.m. on the date of the incident. He went to the house of the informant, PW2, hearing Amul. Reaching there, he saw Jumapur lying on a bed. By the time he reached the place of occurrence, a lot of people had already assembled there. Later on, Jumapur was taken to the doctor, and the doctor declared her dead. He stated to have heard that the accused had assaulted Jumapur, demanding rupees 10 lakh 10 days prior to the incident, and that the accused had strangled her. When PW7 was protected, he stated that when he reached the house of the informant, he found about 15 to 20 people present there. He stated that he had witnessed the accused assaulting the deceased 10 days prior to the incident. So he denied the suggestion that the deceased did not tell him that the accused had demanded 2 lakh from her. At the place of occurrence, he saw the accused sitting on the bed. PW8 is another neighbor of the informant. Likewise, PW7, PW8 also preached, also went to the house of the informant PW, hearing commotion from there at around 1 a.m. in the night. At around 1 a.m. Going there, PW8 stated to have found PW2 dwelling. When PW2 was asked, PW2 told her that Zuma Pop had been strangled by the she saw PW8 stated that she saw Zuma Pop lying on the bed and was not taking her breath. So PW8 noticed a mark on the neck of Zuma Pop. So PW8 also stated that the accused had a quarrel with Zuma Pop 10 days prior to that. When he found Zuma Pop weeping, then seeing Zuma Pop weeping, she asked her as to what had happened. Then Zuma Pop replied that the accused had assaulted her, demanding rupees in her prostitution. PW8 stated that at the time of occurrence, music was being played over a loudspeaker at a little distance from the place of occurrence. On her arrival at the place of occurrence, she found presence of 15-16% there. So PW8 denied the claim. She did not state before she had noticed a black mark on the neck of the deceased, and that when she had asked the deceased 10 days prior to the incident, Zuma Pop replied that the accused had assaulted her, demanding to that. PW9 is another neighbor of the informant who knew the accused as the son-in-law of the informant. PW9 in her testimony in the stated that at around 10:30 to 1 a.m. on the date of the incident, she went to the house of the informant, hearing commotion in commotion, and going there, she found Zuma Pop lying on the bed and her parents weeping by sitting near him. When she asked PW2, PW2 replied that accused had strangled PW9. He Nine had stated that it was then, he informed the maternal uncle of Zuma Pop about the matter of her phone. So the maternal uncle of Zuma Pop then came and took her to the hospital. But Zuma Pop had expired. PW9 stated that the accused attempted to flee from the scene was kept apprehended at the place of the incident. BW 9 also stated that prior to 10 days prior to the incident, the accused had assaulted Jumapol, demanding rupees 2 lakh from her, and he witnessed the incident. In his cross-examination of BW 9, stated that when he reached the place of occurrence, that is the house of the informant, he found the accused inside the room. He denied the suggestions that he did not take to the police about making a phone call by him to the maternal uncle of Jumapol, and that the accused had attempted to flee the scene. BW 10 was working as the senior medical officer at the on 71,006, when he performed post-mortem examination of the dead body of deceased, who, according to him, was aged about 21 years. He stated that the post-mortem examination was performed of his and in reference to that on examination, on performing autopsy on the dead body, he found ecchymosis, he saw ecchymosis approximately is 35 cm length into half cm breadth on right side of neck, reddish in color. The face of the disease was found pale, and her lips were cyanized on back of. As per his opinion, the death was due to throttling or mechanical obstruction of air passages within bracket asphyxia due to throttling. He exhibited the postmortem examination report as EX3, which is signature therein as EX3. In his cross-examination, PW10 stated that the dead body was examined at 1:30 p.m. on 71. He stated that he did not specifically mention as to how and by what substance, the mechanical obstruction was caused. He stated that he did not mention the time of death. He further stated that death can be caused immediately within a second after obstruction or throttling. He denied the suggestion that he did not properly examine the dead. Para PW11 was investigating a property. After receipt of, he stated that after receipt of the after registration of Kozai police station case number 15 of 2015 on receipt of the FIR at around 1 p.m. on 71. He went to the Ujai FRO to meet with the dead body of the victim. He stated that the dead body of the victim as well as the accused were thereafter taken to the police station. At the police station, inquest over the dead body was conducted. He stated that he visited the place of occurrence and drew a sketch map. He exhibited the inquest report as he EXT file. Uh, he executed the inquest report, which was done by the circle officer Ujai as EXT 5. He stated that the postmortem examination on the dead body was performed at the BP Civil Hospital, Gurgaon. The mobile phone of the accused was seized. By EXT by seizure list, by the seizure list, within bracket EXT 6 post of PW 11 stated that after arrest, the accused was brought before the jurisdictional magistrate on 18 months. In his cross-examination, PW 11 stated that one Dhirendra Nag within bracket PW 3 informed at the police station by making a telephone call that his daughter was killed by the accused. The investigation of the case was entrusted to him by the officer in charge at around 2:40 p.m. on 17/1, whereas the occurrence took place at around 12:30 a.m. He deposed that as per the in the previous statement, the informant, PW that PW did not tell him that the deceased and the accused were sleeping. A room, the door of the room where the deceased and the accused were sleeping, was open. That music was played nearby the time of the incident. PW7 declared that PW2 did not tell him that end of the accused was not him, and that PW8 and PW6 did not come to the place of offense. Because he further stated that when he visited the place of occurrence, the door was found open. PW11 stated that PW4 told him that the informed and the accused were taken to the hospital. But PW4 did not tell him that the victim had a mark on her neck. PW11 further stated that PW5 did not tell him that the accused demanded rupees 2 lakh from the deceased. As regards the previous statement of PW6, PW11 stated that PW6 did not state that the accused was sitting nearby and there was a red mark on the neck of him. PW1, who was serving the circle officer, Puja Revenue Circle, on 17/1/2016, conducted inquest on the dead body of the deceased on the basis of police requisition and in reference to Pujai Police Station General Diary entry number 3, dated 17/1, in reference to a general diary. General Diary entry dated 17/1. In her testimony, PW stated that during the inquest, she found some marks around the neck of the body. Later on, command dead body was sent to the district hospital for postmortem examination. Post of PW1 testified that as per the report received from police, disease was strangulated by the accused by her husband. PW1 exhibited the test report as HT1 as signature thereon and carried and PW1 further stated that the witnesses signed on the inquest report in her presence from after completion of the inquest. In her cross-examination, PW1 stated that she did not submit the police declaration along with the inquest report, and she did not mention about any identification marks in that dead body. PW1 stated to have found the dead body in a sleep condition. Will be able to complete. We'll post it tomorrow because we have single benches.
Yes.
Mr. Doctor, it as part of Mr. M. Doctor. As part of
What's your item number 12? That is wrongly listed in hearing column. Paper book is not ready and it was directed to be listed for bail application. What is that I have? 12.
what is the offense?
Offense under section Lordship 302. Lordship, a connected case is there. So Lordship, may I pray that this matter along with criminal appeal number 5 of 2024 may be listed in orders column, Lordship. And in the meantime, if they may, they can file their objection also.
Here has been received.
That's
What do you file your objection? How much? I. Well, for Mr. Yeah, I mean, hard to say. Example. Means if we learn a problem. Sorry, the case record from the MSB not for
3 weeks.
2 weeks.
time to file an objection to the interlocutory file section CRBC. Right. I
The main case-
Along with Lordship criminal appeal number 5 of 2024 arising out of same
pending
judge.
one. There is also
Lordship 318 application is there.
then
Yes, that is
along with
criminal appeal number 5 of 2020.
which has arise of the judgment order for the last.
The main case, LC has been received, paper book.
I have observed in the IA.
Obliged.
For you. Heard Mrs. mentioned. The records of the case records from the learned trial court have been received. The registry to prepare the paper book is the fill up
Obliged.
Since long time.
for hearing.
Yes, Your Honor, but I have mentioned for orders.
It is already fixed for order hearing, then it should be pursued before the registry.
I have checked the record,
Have
but
you
it is
seen
not
the-
found.
Already fixed for hearing?
No, Your Honor. Not fixed for some service report has not been completed.
Have you got the previous order?
No, Your Honor.
Don't
It
make
is it is not found in the online system. E-code survey.
a form.
It is not found in the online system. And the case was misfiled. I have applied for the certified copy. I'm just newly engaged in this.
What
Yes.
are the previous order? Is the if the criminal petition is of the 2016,
Yes, sir.
right?
Yes, sir.
So it is about 8 years old.
8 years old. 8 years old. That's why I have mentioned this matter for order.
So if it is fixed for hearing, don't make lots of time. It is to be pursued before the registry. If it is fixed for hearing.
Yes.
Be sure about it. Otherwise, it will not be appreciated.
Okay.
Come up with the previous order. So it is fixed for hearing or for any service report or something like that.
After I will receive the copy from the.
Mention in the matter which is already for listing in order. Am I clear?
Misfile হয়েছে মানে
Find out from the registry.
December.
Please, my lord. But I pray for a fresh listing of a criminal petition. I pray for a fresh listing of a criminal petition for Friday, my lord. I'm obliged.
Please, your lordship. Lordship, I beg to mention for listing of a criminal petition, my lord, which was for hearing. It was supposed to be listed today, along with item number 13, my lord, because since both the matters are interrelated and is pending before the same court at Hailagandhi, my
No,
lord.
by order we can. Not ready.
Right.
Earlier mentioned was filed misleading in this court. It was fixed for hearing. And mention was made for hearing. No mention is permitted. Decline. Not picked up. Because order was fixed for hearing on a date to be fixed by the office. So when something is to be fixed for hearing, the application will be filed. Because the earlier coordinate did not fix anything for it. There has to be system
Lordship. With the consent of the other side, I would like to mention item 5 of today's. I'm for-
5.
Yes, Lordship. We need to file an additional affidavit.
You need to file, you are for the petitioner.
No, Lordship. I'm for respondent number 4. I'm
Did you
appearing.
file any affidavit?
No, Lordship. We need.
Then
time
how
for-
additional?
Oh, sorry. We need to file an affidavit.
Yes, Guwahati High Court. You're for Guwahati High Court.
Respondent number 4. I'm on behalf of
I need some time for file.
Okay. You are MS
NDECA
and DECA Learned Council. Okay. For respond number?
4.
Mr. H.K. Das, Learned Standing Council GHP. For the respond number 2, 3, and 5, and MS and DECA Learned Council for the respond number 4 have paid for and are granted 2 weeks time to file their respective counter affidavit. The prayers are made with the consent of the Learned Council. Release the case after 3 weeks.
Made legal lordship. Lordship, I beg to mention a criminal petition for listing lordship.
Orders
Yes,
or
lordship.
admission?
For orders, lordship. For
Of which year?
matter may be listed on Friday, lordship.
Not by them, no? Court must will give it.
I beg to mention item number 8. Your lordship, my senior is out of station. Kindly on the
Okay. On the prayer of
Here, madam, charge sheet already submitted.
on the prayer of your name, please. Your name, please.
Edas.
Edas. Learned Council appearing from Mr. B. Decker. Learned Council for the petitioner. The case let the case be listed on the video. Mr. B.V. Gogoi, Learned Additional Public Prosecutor, has submitted instruction, after completion of investigation, the IO of the case has already filed a charge sheet under section 173 to CRPC. Any number is there
Yes, yes.
by charge sheet number?
Charge sheet number 96 public 2023 dated 30th 6 2023.
Who needed to list the case on 8.
My lord, this petitioner, he was arrested on 22 May. FIR is page 13.
FIR
page 13, May.
So alleged stolen
Yes, but only fact is that-
commodities were
Yes, yes.
seized from you.
Yes, my lord. I am not, I purchased it.
Whatever,
Yes, sir.
it is
We purchased it from one article, my lord.
BDS items of
No, I-
large quantity.
Yes, sir. We purchased, I and my brother purchased 155 bags from one article. Then, my
We
lord,
do not know that Kaiser will reveal.
yes, sir. It was.
Kaiser will reveal.
No, that has been recovered from our position, 155 bags. Yes, recovered, but what happened, my lord, after arrest, my mother expired on 24 May. I could not perform, only driver, handyman, all are arrested, my lord. All are arrested. Driver, handyman. My mother expired on 24. I could not attend also funeral ceremony. Now, her 7 days work is going to be held on tomorrow, no? Tomorrow. Well, I am a purchaser, my lord, actually. I made a statement, my lord.
Otherwise, primarily
And my-
it is
my-
evident that you have.
My lord, my statement, everything
These
has
are
been
all-
recorded, my lord. Everything has been recorded. Only my mother expired on 22. I annexed the certificate issued by the Gavura. I also applied for the death certificate, my lord.
Mr. Today is past May. Okay, come to your paragraph 7.
Yes, my lord.
Read.
President Baxter, the 7 days religious work will be held on 31.
We don't find such, we don't
Highlights,
find,
it should
we
be
don't
one.
find such
My lord,
date
my lord.
in any calendar in the
My lord,
history
my lord,
made,
it's- my lord,
ever made.
It should be one, my lord. Typical. It should be one, my
So it is already over.
lord. Only the one. My lord, my statement is that I stated that we purchased it from the one article.
We
article.
can ask for an early date, we can request Mr. Gogoi at the earliest. At the earliest,
My lord, sorry.
at the earliest.
My-
And what could be the earliest?
It is
Mr. Gogoi?
from Azora, my lord.
Seven. Oh,
Holiday,
seven holiday.
voting day.
April 5, my lord.
Then 5 Sunday. Then 6, my lord. 6.
Okay, that could be the earliest. Heard Mr. D. Ahmed, learned from. And Mr. D. Gogoi, and petition of 5 September. Yeah. Yeah. Mohammed Azizul Haq has paid for his release on date in connection with other application. Case number 85, stroke 2024, registered for document 407. Mr. Gogoi learned of release the case on 6/5/2024 to enable the learned additional copy produced by the
Hello.
Made, please, Your Lordship. My lord, the challenge before your lordship is the complaint filed before my lord Calcutta and order taking cognizance on the complaint filed by my lord respondent companies. My lord,
Your ground of telling is that
my
most of the cause of action
at Jorhat, your lordship, and my lord, ingredients of 420 and all not attracted because from the very first day, my lord, because payment was made by me, page 20.
Okay, tell me, Mr. Goel,
My lord.
the complaint was filed before the Court of Learned Metropolitan Magistrate. So, taking cognizance on the complaint under 190 CR, finding the process has been issued under either section 200 or section 4 here. And the Metropolitan Magistrate has exercised its jurisdiction under the provisions of the CRP.
Yeah.
Now, you will come up with a set of judgments right from Nobin Chandra Madhitha.
Our High Court also.
Right. Tell me, in any of the Supreme
My lord.
that an order taking cognizance on a complaint by a judicial magistrate exercising power under the CRP of another state has been interfered with a high court by a high court of another state, having no territorial jurisdiction.
True, your our
So-
High Court.
So no, our high court no. I may disagree with our high court. If I find that that is not in terms of the provisions of law,
Under
tell me any Supreme Court judge.
the decisions of Honorable Apex.
Tell me
My lord, the
judicial order passed by a judicial magistrate or metropolitan magistrate of a high of another state
my lord.
over whom
My lord.
another high court has supervisory jurisdiction, and which this high court does not have territorial or supervisory jurisdiction. Other cases which we'll be referring to
FIR.
right from Nobin Chandra Madhitha,
Kusum
and all this pertains to investigation. Show me any judgment of the Supreme Court where a judicial order of a metropolitan magistrate or judicial magistrate exercising power under CRPC, taking cognizance, issuing process, who is under the supervisory jurisdiction of another high court and who is beyond the territorial jurisdiction of this high court, can this high court, going beyond its territorial jurisdiction on the pretext of 226(2) can exercise?
I
1 minute. Firstly, it is settled position law, a judicial order cannot be challenged in a writ petition. I am giving you this clue. A judicial order cannot be challenged in a writ petition under 220. I have found petitions being filed.
In fact, I have order also of this honorable court. Where
No,
the
then I stand corrected. I did not state a proceeding. I state only execution. If my order is there,
no, my lord, this is the
I
order.
may be wrong.
Here the proceeding has been stayed by this honorable court.
That is an interim order,
Interim.
not
On
final.
the basis of the decision which I was likely to
So,
place
on the
before your
ba-
lordship.
So basis of that order is all those Supreme Court judgment. Show me any.
Tomorrow,
Show me.
your lordship, absolutely, FIR is there. Tomorrow, let this matter be taken up tomorrow, my lord. I will
come up,
my lord. In fact, this is that question which your lordship is asking. It was in mind, but I was under the impression that since this honorable court has entertained, and
I am not entertained.
this
till date.
court, that's why I am saying, my lord, this honorable court, my lord. Your lordship is also part of this honorable court. Entertained, and the reason of honorable
Now
aspects of
our
court-
coordinate benches, final judgment. All those final judgments.
final judgments are in respect of absolutely FIR. I will
Show
find-
me anything from the Supreme Court first.
Will tomorrow, yeah.
Friday.
Friday on third matter is on third, your lordship.
Otherwise, I am not inclined.
My lord, I will try. This is learning, your lordship, and I will try to find out
Because
my
the
lord,
best course is available
my
for
lord,
you.
FIR
482 before the High Court, which exercises territorial jurisdiction and supervisory jurisdiction over that court. Or a petition under Article 227 is also maintainable in respect of criminal matters. That has been held by the Supreme Court.
but I am
Now,
here.
227 and judicial order, a judicial order can only be challenged under 227 provided no other recourse is available. And even in criminal matter.
That's why we
And
are-
that 227 is exercise of supervisory jurisdiction. Let us see article.
That's why we are saying, my lord, there is no concession because there is exception. So I think, my
I
lord,
know behind the judicial order, complaints are filed before courts of another state just to cause harassment. That I am aware of. So most of the cause of action arises within the state of Assam. A vehicle has been purchased
Everything.
in Assam.
Loan
is extended by a branch office here. Checks are given here. Installments are paid. But
arbitration
all these,
proceeding has been initiated by them.
all these proceedings have come under a judicial order. That is a slight difference. And slight distinction in facts
Because
makes
of
a whole
complaint
lot
case.
of difference.
Complaint case.
So by staying the order may amount to an illegal judicial order.
Judicial, I understand.
Have you understood?
On Friday,
227(3).
220.
Every high court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. And 227 is barred because it is a judicial order.
But 226.
This is my tentative view.
226 2 says, your lordship,
226 is what? any kind of judicial order is not to be challenged in a petition under Article 56. If that is so, and that is not by a small bench, 9 judges bench, 9 judges, and standing the test of time in last 6 decades. I've heard Mr. A. Goel and Council Court of Petition on his pair, raise the case on. Right.
Deeply.
Application, my lord. FIR is page number 9, my lord.
9.
9, 365, my lord.
No strike
Listeners here in Adda, my lord. Parents, grandparents, and maternal uncle, my lord, of the
money criminal Aru Welor Good Bhagi and these petitioners are
my lord, parents, grandparents.
other than Soel.
Yes, my lord. Parents,
Other than
grandparents, and my lord, maternal
Yes.
uncle, my lord.
Mr.
Well is not before you.
Of the party.
Nothing alleged against them, my
No specific allegation.
no, my
Against that 12 only.
Heard Mr. M.D. Kwadi, learned counsel for the petition, and Mr. B.B. Gugoi, learned also by this application under by this application, command of petition, VIJ 1, 2, 3, 4, 5. I have approached this court seeking the benefit of free restraint under section 438 TRPC in connection with Agamoni Police Station case number 05 2024, registered for the offense under section 365 stroke 34, Indian Penal. The first information report was lodged by one Kasim Ali on 20/01/2020, wherein the 5 petitioners herein are named along with one Suel Rana Elias Manik. As per the allegations in the FIR, the daughter of the informant, aged about 17 years, has been kidnapped by Suel Rana Elias Malik at around 8 p.m. on 19/1/2020. Where Mr. Patil and counterpart of petition have submitted that the petition number 1 and the petition number 2 are the parents of Suel Rana Elias Manik. The petition number 3 is the maternal grandfather, whereas the petition number 4 is the maternal uncle of Suel Rana Elias Manik. The petition number 5 is the maternal grandfather of the Suel Rana Elias. He has further submitted that no specific allegation has been attributed to any of the petitioners. The FIR as regards the act of alleged kidnapping of the minor daughter of the Mr. Gogoi learned public prosecutor has submitted that you produce the contract 16/5/2024. having regard to the fact that there is no specific allegation made as regards the specific attributed the petitioner with respect the alleged act of kidnapping of the minor daughter of the and considering the relationship of the petitioners with Joel Rana Elias and this of the case 25,000 one COT
Obliged.
10 days before I
Obliged. Highly obliged.
release the case on
16.5.
16.
Obliged.
Yes.
In this case, Lordship, the petitioners are serving as the Saraswata and supervisory assistant under the district judge, district and session judge Karimganj Court. And
You are serving as
Saraswata
solicitor and supervisory assistant. Okay.
under the district and session judge Karimganj.
Okay.
And their service condition is governed by the Assam District and Session Judge Establishment Ministerial Service Rule 1987. And they have been expecting that their promotion would be given in proper time. But in 2014, Lordship, one of the person that the private respondent hearing, he has been promoted to the post of UDA in the year 2014 by the district judge. He's a person from different cadre. He's under the Motor Accident Claims Tribunal. And this is under the Judicial Department, Government of Assam. At that time, they filed application, representation before the authority concerned. But that time, they did not take any action.
You've been sitting over the matter for
No,
last 10
Lordship,
years.
I'm coming to that point, Lordship. That time, they did not know about that, the promotional order was a conditional order. Only they have given that he is a person from a Motor Accident Claims Tribunal. How he has, can be transferred in the judicial department. But the authority did not take any action. Subsequently, that person has been promoted up to the post of head assistant under the district judge, Karimganj. Recently, they have come to know about some of the anomalies that took place during that period in 2023, Lordship. When he applied for the post of chief administrative officer under the district and session judge Karimganj. After coming to know of disparity regarding the promotion, they filed application before the authority, and but till today they have not received any information from the authority concerned, Lordship. Can you turn to page 52, Lord? Annexure 5, Lord.
Have you served a copy to the standing council, Mati High Court?
I've informed.
You should have served a copy
Yes, Lordship, that is my fault, Lordship, because
because there his name is not showing.
not
What,
Yes.
what kind of urgency now?
no Monday. I will leave the
Monday then we'll take up on Monday or Friday. Serve a copy.
Friday, no, not Friday. I'll be out of station Monday.
There is no
Please-
interim prayer.
please-
Huh?
Interim prayer tonight.
Interim,
Then let us on
only
Monday, let
interim
us on Monday.
Monday, Lordship.
Because he will be better position, he will be in a better position.
Yes,
to
Lordship,
understand.
because one of the employees under the department has filed also application before this honorable court. But
He, the
inadvertently,
petitioner's
I have
grievance
pen-
is that a person from the transport department
Yes.
is holding post under that service rule
I think
1987.
this respondent number 6 has also filed a writ petition. So that's
he
why.
is claiming that promotion, Lordship, regarding promotion of that.
Okay.
That is an
I'll
Different
check up,
aspect.
my lord, and I'll
You
apprise your lord.
Get the
I'll-
information
I'll
about the
serve.
other requisition also in them.
Yes, yes.
We'll take up on Monday.
Yes.
The motion for
Yes.
third MSM tape planet for the petition. And MS any Mr. Nath can take notice on behalf of Judicial Department. Mr. D. Nath, Senior Government Advocate, Assam for the response number 1.
Judicial department is one, then transport.
Then Mr. Das will report
2, 3, and 5.
MSCT comes under you.
MSCT, my lord, some doubtful, my lord. I'll have to seek
MD Bora?
clarification.
Transport
Huh?
department. I am for 4, my lord.
My lord, we are doing, I'm appearing in some
Okay,
matter.
okay. Mr. H.K. Das, Learned Standing Council, Guwahati High Court, for the response number 23.
5 also.
And 5.
I am
MS MD Bora, Learned Standing Council, Transport Department, for the full stop. Mr. Das, Learned Standing Council, DHC, submitted a copy of the petition and has not been served. Full stop. MS Dave, Learned Council, for the petition has submitted a copy of the repetition along with annexer will be applied to Mr. Das by tomorrow.
tomorrow.
Yes.
By tomorrow.
Yes.
And the repetition will be listed on Monday.
6th.
6 case against recording on 5
Okay.
reflecting the name of Mr. Iskeda and
Yes.
standing of the AHC as the for the response number 2, 3,
3 and
and
5.
5 in the respondent side of the cost.
Okay.
Deeply.
Yes.
Yes, lordship, we have taken steps on matter. No case against this.
Okay.
That will be reflected.
Heard Mr. N.J. Dr. Learned Counsel for the petition and Mr. B.B. Gogoi, Learned Additional Public Prosecutor for the respondent state of Assam. The petitioner in the instant, I go repeat for you second paragraph. Mr. Gogoi, Learned Additional Public Prosecutor, who was asked to obtain instruction on 34/2024 from the officer in charge Sipaja Police Station
On a structure.
as to whether any case has been registered against the petition at the Sipaja Police Station or not. So today, Mr. Gogoi, Learned Additional Public Prosecutor, has submitted, on instruction, that no police case has been registered against the petition at Sipaja Police Station till date. So, in view of the above instruction placed by Mr. Gogoi, there appears to be no necessity to proceed further with the instant application 7, except observing that if any necessity arises for appearance of the petitioner in connection with any case registered at Sipaja Police Station, the requisite procedure laid down in the Code of Criminal Procedure 1973, the police authorities shall ensure compliance of the provisions of the Code of Criminal Procedure 1973. Ensure compliance. 41 maybe.
Yes, petitions can close.
To proceed further with the so accordingly the application the instant application is closed. They will accept. Okay.
I'm obliged.
Wait, Your Lordship. My lord, I was arrested on 3/1/24. My instruction goes, my lord, charge sheet has been filed on 31/1/24. And
Report had yet well application.
Is it received?
Was called.
Received.
FIR.
Lordship, FIR page number 9, Lordship, this type of.
9.
Yes, Lordship.
Who is this petitioner?
Lordship, I'm the owner of the vehicle. The helper already arrested.
What
the
is your
absconded.
ground for seeking period bail?
Lordship, that's the driver is absconded, Lordship, and helper is already arrested, Lordship.
Without
I'm
your
the owner
knowledge.
of the, yes, Lordship.
Without your knowledge. Without your knowledge, they have been carrying.
Yes, Lordship, that is my.
That is a
ground, Lordship.
standard, very standard one.
I'm the owner of the vehicle, Lordship, the public
You
carrier.
are from which
truck,
place?
Lordship. I'm from Lordship,
Hailakandi itself.
yes, Lordship.
Hailakandi.
This is the island resident is
Huh?
Lordship,
You're
the
from which
Qatar
place?
district, Lordship.
Katigora, Qatar.
Yes, Lordship, in Qatar.
And the police station?
Ramnathpur is the district of the
Ramnathpur.
Hailakandi, Lordship,
Hailakandi, nearby.
nearby.
So you have the control of the vehicle. Had it been Dibrugarh or Dhubri, we could have bought that story.
Still, Lordship, driver is the helper is the.
You're not in a position to buy that
owner
story.
is, owner is in the staying in the. Qatar
Yes.
district.
Yes, my lord, he is the owner of the vehicle, my lord, that is there. And co-accused with the handyman, my lord, he has been arrested, my lord. The driver fled away, my lord. He is name one person, my lord, Sophia Laskar as driver. Do not, my lord.
Whether he appeared.
Which?
Interim order was granted.
Oh, yes, yes, yes. He appeared. His statement recorded.
So any requirement of custody?
Requirement of custody, only that investigation is going on, my lord. The driver, my lord, yet to be apprehended. And that
Whatever
were
the
not found
custody,
from the chief chamber.
He sought custody.
No.
Custody of the vehicle.
Yes.
He sought. Yeah, Ambata. What is it? Now, Zimma petition filed by him already allowed.
Yes.
Subject to execution of Zimma bond. Then, since he has joined an investigation, then this is the order.
Yes.
Zimma petition filed by him is allowed for the vehicle only. For the vehicle. Nowadays, whether this Bitland can be examined by FSL,
That report here.
that you will not never get, because I have heard that forensic science laboratory have started refusing to examine
It is
Erekanat. because they don't have the technology to find out whether this is of Indian origin or foreign.
Only
They don't
can
have
say
the
edible or not, my lord. That is all. They can say only edible or not,
Right.
human consumption.
Right. But whether it is of Burmese origin or Indian origin, they don't have the technology.
Those are, my lord, doing this business. They know, my lord, after looking at
Those who are in the business, they
That
know.
is a-
Hard, MS,
Are wrong, my lord.
are wrong mind. Petitioner definitely knows. Learned counsel for the petitioner and Mr. B.V. Gugoi, learned additional public prosecutor for the respondent state of Assam. By this application, the petitioner has approached seeking the benefit of free airs bail under Section 438 here in connection with Ramnathpur Police Station case number 07/2024, registered for the offences under sections 120B, 420, 379, 411 of the Indian Penal Code. Agor order to para 3. The petitioner has been extended interim protection by an order dated 10/4/2024, with a further direction to him to appear before the IO bracket within a period of 10 days from 10/4/2024. So, Mr. Gugoi, learned edition of prosecutor who has received the concert case date, has submitted that the petitioner has in the meantime appeared before the IO brackets in reference to the order dated 10/4/2024, and upon his appearance, his statement has been recorded under section 1 of the para. From the materials available in the case diary, collected in court of start, it transpires that the alleged Arakanat of suspected Burmese origin, are already been seized. It is the MS Roma and it comes for the computer pursuant to the order dated 10/4/2024 and has joined the investigation, and the petitioner will continue to extend his assistance and cooperation in the further investigation. It is further noticed that the petitioner, who is the owner of the vehicle bearing registration number AS01/FC -9515, which was carrying the betel nut, betel nut of suspected Burmese origin, had preferred a Zimma petition before the Court of Learned Judicial Magistrate First Class Hailakandi, and by an order dated 9/4/2020, the Court of Learned Judicial Magistrate First Class Hailakandi allowed Zimma of the vehicle bearing registration number AS-01/FC-9515 the petition on execution of a Zimma bond of fees 30 lakh. Having regard to the fact, aforesaid fact, and more particularly that the petitioner has joined the investigation. This court is of the considered view that for the purpose of carrying out further investigation into the case, Samantha still in detention of the petitioner appears not necessary provided he continues to extend his assistance and cooperation in the further investigation of the case and subject accordingly, the interim protection granted to the petition by order dated 10/4/2024 is made absolute subject to the following condition of the court.
Much obliged.
Mr. Mehdi, just
ma'am.
will pass dispose of this order matter to three. Then we'll take up. Yes, madam. It will show within a period of 7 days from today. Will be.
Please, your lordship. Lordship, in this matter, lordship, we have taken fresh steps. However, lordship, answer
is
notice.
quashing.
Lordship, for quashing, lordship, an agreement has already been come into between the parties. Lordship, and lordship, actually, this pertains to some lordship for some sale of land by deceitful means.
So why it is come for?
For quashing of the FIR,
Orders
lordship.
today.
Today, why?
Today for orders, lordship.
Orders.
Have you seen the office now?
Lordship, unserved notice in respect of respondent number
2 has not been
has
served.
been received.
3 has not been served.
No, unserved notice has not been received, lordship. We had served, fresh steps were taken. Respondent number 3 is out of station for a long time, lordship. Therefore, the unserved notice has been returned back. Otherwise, lordship, the parties have come into an agreement, lordship.
But
Formality, we have
Lordship,
to
lordship, this formality, lordship.
or agreement, even that it would amount to cutting.
Lordship,
The presence of the other party should be ensured.
lordship,
If you have come to an agreement, why don't you inform?
But lordship, the problem is that lordship, they were employees of the company, and lordship, now they are evading. Otherwise, and lordship, also a case under 130.
But you have to serve for
Lordship,
passing.
I know. Lordship, we have taken steps twice, lordship.
What to do? It has to be served. Without hearing them that the complaint is to be FIR is to be quashed. That is not proper hard mess.
People.
P. Borua. And counsel for the petition. Therefore, carefully.
one
No, lordship. Now they are not. They are no longer here, lordship. They are on bail, and lordship.
Petitioner. And Mr. B.B. Goel and in view of the office note dated 29/04, MS Borua and petitioner have find out their face address, have submitted that endeavor will be made to take steps for service of peace in the press and the public. Upon the response number 2 and 3 at their correct and proper addresses within a period of 2 weeks by registered petitioning. So the prayer is loud. List the case after 6 weeks.
Lordship, 4
It
weeks.
is, no, 2 weeks, then after to go
Another
by
4
register post. If you can serve it by dusty, I can make it 4 weeks.
No, Lordship, it will be very difficult to find them. That's it.
Office to. Then raise request for the scanned copy of the TCR, trial code. Already ordered scanned copy. No. Okay. Not the scan.
Earlier CD was also called
CD,
for that.
CD.
Yeah, that is also not visible.
Mr. Who has submitted that essay of alternative of 2022 has not been received, whereas Ms. Urwa, with whom you have entered
Lordship,
into agreement.
Lordship, actually, this is a joint petition. The petition number 1 was the employee, petition number 3 is the director, and petition number 2 was one of the accused of the FIR. Now, Lordship, the sale deed is complete, and Lordship, there was a
Oh,
tripartite.
why you have made these 2 and 3? Who are they?
Lordship, 3 is the director.
The joint petition.
On joint petition.
Then you have continue. To continue their name 1, 2, 3, 4.
No,
Like that.
3 has been impleted, Lordship. By the
3 has been implemented,
Lordship.
right? 1 and 2. Then who are 2 and 3?
2 and
What
3,
number
Lordship,
2 and 3?
they were 2 of the accused. There were 3 accused persons in total in the FIR. Petition number 2 is one of them. Lordship, now sale of deed has been complete. Petition number 2 has also agreed for this quashing. But 2 and 3, respondent number 2 and 3 are evading. However, Lordship, if it is quashed, it will be to their benefit. Allegations against them will also be quashed.
Their benefit.
Who is the informant?
Informant is petition number 1. Petition number 3 is the director of the company in which informant is also working. Informant is the employer. Page number 26, which is the tripartite agreement.
This agreement is subsequent.
Lordship, sale of deed is also complete. Therefore, Lordship, we have approached this honorable court.
There are things that You have fixed it. But you take the steps.
Lordship will take this. Deeply obliged.
May I please? See, IA is for saying the proceeding and saying the available warrant of arrest. Well, what happened in this case, my lord? Let's go through the main case, my lord. There was two FIRs lodged against me, my lord, against us. One is in
No,
Jalukbari
you are filing criminal petition for what?
for question
Let
of
me
the, my lord,
understand.
the proceeding of proceeding or FIR. Pursuit of-
ER case number. What? You are challenging what?
in the IA or in the, my lord,
In the main petition first.
in the main,
First to understand.
my lord.
So, my ER case.
Wait,
First. What?
right? Crossing FIN as well as the statute.
What? Third first. Third. So, criminal petition has been filed. Was the proceedings of ER case number 435 2012 pending before the judicial for the Ipu and the third. Right? Now,
Now, my lord,
one.
now, my lord, in Jalukbari PS case number, I got acquitted. I think my lord, 300 CRPC will attracted. Now, my now today is my lord, the respondent note 2 and 3 is not appeared and notice also not typed. Therefore, I come with the
You are
IA.
seeking passing of
Difu. Their case number.
ER case number 435.
Yes.
Now, in what connection is available warrant?
In the Jalukbari PS case number, my lord, the same vehicle which was alleged to be theft by the accused,
No,
my lord,
BWA has been issued in connection with what?
in connection with Difu, my lord. Their
Ipu.
case,
We are concerned with that.
my lord.
I have seen the order system of the criminal petition. There is no interim order.
Well,
Court in none of the occasions previous has found it appropriate to state a proceeding of ER case number 435.
my lord.
Meaning thereby, you are obligated, you are under obligation to appear before the learned trial, which perhaps you have not done.
My lord, in
Is
the
it not? Who is the petition? Mohendra Doimari. And read out.
Leader Basumati.
Now, where is the order? Let us see the order sheets.
Order BWA, my lord, in IA, my lord,
Abuse of the process of the court, 5,000 each.
my lord.
5,000 each. Oh, dismiss. Hard.
My lord, kindly, my lord, appreciate my lord.
You are abusing the process of the court. This court has not found it fit and proper to state a proceeding of the GR case number so of 2012, since the very beginning, the proceeding started on 20 July 2020. It is about 2 years. 10 orders have been passed. Court has not found fit and proper to stay the proceedings of DRCS.
In the past that
Just because filing of a criminal petition does not mean that you are not under obligation to appear before the learned trial court.
I was appeared.
This is abuse.
Initially, I was
5,000 each. This is going beyond the limit.
In the initial stage, my lord, I was appeared. Last 2 days, I was not appeared, my lord, in the trial court, my lord.
This is going beyond the limit. It is by BWA only. This is trying to bend the process of court. Hard.
My lord, kindly consider, my lord. I will take instruction, my lord. Let the matter
Tomorrow.
today.
That will be 10,000. I'm making it clear. This is total abuse of the process of
10,000, 35.
You have to deposit to the state exchequer at Ujai. Bailable warrant of arrest. On what ground? Last 2 years you are not appearing. Just because you have filed a criminal petition here.
I was appeared, my lord.
When? Show me. Which date?
Initially, I was appeared.
Which date? Every minute spent will increase the cost. Is there any law that a criminal petition is filed, no interim order is passed, staying the process? He is free from appearing before the court for last 2 years. And people will say that the court is delaying the proceeding. People will come, hammer and tong, that there is to be delay, long delay in completion of the proceeding. And this is the way, one of the ways of delaying the proceeding.
My lord, I was appeared and take bail, my lord, from initial stage, my lord. At 7/9/12, I was appeared, my lord.
7/9?
7/9.
Where?
Accordingly.
Which document? At least we are clear from 10/7/2023. Bailable warrants are being issued against you since 10/7/2023. Page 60. Bailable warrants are issued only after issuance of sum. Mr. Burman, this is going too far.
I will take the order sheet, my lord. All order sheet is not here.
Not required. At least we are clear from 10/7/2020, page 16 on. We are quite clear that the process of the trial is being delayed because of your absence, continuous and repeated absence. And you are still trying to. Bailable warrant of arrest is part. Third, Mr. Informal. Mr. Vivek. It will be increased. Please check. On the prayer of Mr. Burman, release the case. Yeah. Not will be increased. I'll make it sure. Keep it avoiding.
My pleasure.
It's the difficulty, having a division bench also. After that, single bench.
Yes. On last second, Lordship, hard matter.
This question is having time to pass the order.
Yes. And because of the not, service was not completed, so sent for. Sorry.
Mr. Mehdi,
My lord.
what I propose is it on Friday. We'll be having a single bench.
This Friday.
No division bench.
Unfortunately, my lord, one case is fixed in Dimapur.
Huh?
One case is fixed for Dimapur, my lord.
Because division bench will
Yes,
not
sir.
be sitting.
Yes.
Right. So I could have dealt with this time. I will require some time also.
Yes, yes.
To go to the law.
Yeah, I have submitted a written argument also in
Yes,
yes, yes.
I'll not go by your written.
Yes, yes, yes.
Am I supposed to go?
No, this is for
I'll take note of your
Yes,
written
yes,
submission.
yes.
I'll only go by the law.
Yes, my lord, that is true. As a counter, my
To read also need some time to dictate.
yes.
You are not available.
My lord, the whole matter.
Monday?
Monday, my lord. Monday. Six.
Then we can take a chance on 6.
Six second half.
I don't know whether division bench is sitting on.
Yes.
There is a 50-50 possibility division bench may not sit. In that case, it will be single bench. And I will have the proper time. And precedence is to be given to the bail applications also.
Yes.
The same. Your case is given.
Yes.
Try to get it on.
Six. Yes. But second half, my lord.
Whatever is possible.
Yes.
Heard Mr. Estimated running off the meeting.
Yes.
And Mr. B.B. Goyal despite service of notice upon the response but none has appeared to represent the response number 20. Due to paucity of time, that cannot be taken up today. So stop as agreed by the short provider transfer for the party. Four for February. I wanted to dispose of
Yes,
this.
on last second.
Find out the law. Petition. That how you have made to list it for hearing
My lord,
by mentioning.
by mention was done, my lord, but not by
I have
me.
seen it.
But not by me, my lord. My junior colleague, he mentioned the matter, but he didn't say me that directly hearings are not placed by this court by way of mention. We have
No, this is not the practice of this court. This is the practice of the honorable chief justice.
I seek
Don't make
apology
an
on
issue
that.
for
I beg apology, my lord. So, my lord, since
I am trying to follow.
yes, yes.
But the courts are following.
My lord, that today earlier I tried to make a mention regarding a matter, my lord.
If you want a hearing, make an application. for early hearing. Plots are in the queue. Like an application.
Yes.
Passing it. I want to be clear. Make an application.
Yes.
For early hearing. Post it.
Yes.
Don't bring anything on for hearing in the hearing column by making mention.
Yes. I seek approval.
That column is not there in the mention memo.
No.
Mr. Counsel,
Yes, my lord.
is it there?
No, my lord.
Motion,
Orders
admission,
and orders.
order,
Yes.
no hearing.
No, yes, my lord.
This is a time-tested procedure.
Yes.
Don't try to overcome the process.